Thank you so much for coming for today's lecture. I'm really excited to be hosting Professor Gordon, talking about his scholarship. I want to first start off by saying, you know, a year before going to law school, we all, I know I was in a position of going through the websites of every single law school and looking at their professors and this and that and doing pro-con lists. And I specifically remember the day that I told my wife about some University of North Dakota somewhere had a professor that was a prosecutor for the UN War Tribunal in Rwanda. And I just thought that was amazing because my wife and I, she's lived in Africa and we are both fascinated about that topic. And so I want Professor Gordon to know that he was the first pro for my pro-con list for North Dakota. And he overcame the con of the snow. So we don't have much time, so I'm going to do a quick introduction of Professor Gordon. Professor Gordon is the director of the UND Center of Human Rights and Genocide Studies, and he teaches courses in criminal law, criminal procedure, international law, and international human rights law. He earned his Bachelor's of Arts degree and Juris Doctorate at the University of California at Berkeley. He then served as a law clerk to the United States District Court Judge Martin Pence in Hawaii. After a stint as a litigator in San Francisco, he worked with the Office of the Prosecutor for the International Criminal Tribunal for Rwanda, where he served as legal officer and deputy team leader for the landmark media cases. The first international post-Nuremberg prosecutions of radio and print media executives for incitement to genocide. For this work, Professor Gordon received a commendation from Attorney General Janet Reno for service to the United States and international justice. After his experience in the International Criminal Tribunal of Rwanda, he became a white-collar criminal prosecutor with the United States Department of Justice Tax Division. Following a detail as a special assistant United States attorney for the District of Columbia, he was appointed as the Tax Division's liaison to the Organized Crime Drug Enforcement Task Forces, for which he helped to prosecute large narcotics trafficking rings. Also during this time, he was detailed to Sierra Leone to conduct a post-Civil War justice assessment for Department of DOJ's Office of Overseas Prosecutorial Development, Assistance and Training. He has been featured in C-SPAN, NPR, and BBC, and Radio France Internationale, among others, as an expert on war crimes prosecution, and has lectured on that subject at the U.S. Army JAG School, the Harry S. Truman Presidential Museum and Library, and the United States Holocaust Memorial Museum. His scholarship on international criminal law has been published in leading international academic publications such as the Columbia Journal of Transnational Law, the Virginia Journal of International Law. He has presented his work at institutions such as Yale University, Georgetown, Emory University, among others. And he was the inaugural winner of the North Dakota Spirit Law School Faculty Achievement Award in 2009. And in conclusion of his bio, he in 2010, he co-wrote the United States Supreme Court amicus brief of Holocaust and Darfur genocide survivors in the historic human rights case Yusuf v. Cementar.
You know, it's always such a privilege to be able to present my scholarship. It's such a great job that we have here to be able to think about issues on a large scale and then to work with students and exchange ideas. And I think it's a great interchange that we get with the students in doing our scholarship. And I like doing this anywhere I can if there's an audience that wants to exchange ideas with me, but it's especially an honor to do it here at my home institution, University of North Dakota, and I'm so grateful to be among you today and to be able to present this. And I want to thank Tim Heise and the International Human Rights Organization for giving me this opportunity to do it today. I'm presenting today my latest paper, which is called, today's title is Hate Speech as a Crime Against Humanity, Beyond Incitement to Genocide. The title of the paper, which is going to be published by the Vanderbilt Journal of Transnational Law, is Hate Speech and Persecution, a Contextual Approach. And what I'd like to do is talk a little bit about some threshold issues that I think will be helpful to frame my comments today. First of all, there are three core crimes involving gross human rights violations that you should be aware of. There's genocide, of course, the crime of crimes, quite famous. war crimes and crimes against humanity. Crimes against humanity you don't hear spoken of as much. War crimes typically involve offenses committed by military personnel, all right? It makes sense. It involves war. Genocide involves an attempt to destroy in whole or in part a national, ethnic, racial, religious group. As such, it's destruction of a group, okay? It's an intent-based crime, extremely hard to prove. Crimes against humanity involves a series of crimes, murder, rape, torture, deportation, those sorts of things, committed as part of a widespread or systematic attack against a civilian population. Much broader in application, certainly, than genocide, because it doesn't involve destroying a group because of that group's identity. Again, a very hard thing to prove. Now, the other thing that we have to consider is that speech is connected to atrocity crimes, the three that I just mentioned. And the law of war, interestingly, humanitarian law as it's otherwise known, currently has no speech crimes that provide for liability for the speech itself. Now, my previous article that I published earlier this year proposes a new crime, incitement to war crimes. But that's just my idea, and so far it does not exist in reality, which is unfortunate. Incitement to genocide is the speech crime that you hear talked about all the time. That's what people popularly think of as the speech crime related to atrocities. The problem is that in order to prove incitement to genocide, you have to show that the mental element for that crime is the destruction, the intent to destroy in whole or in part, those groups that I talked about because of the fact that they were those groups, because of their identity. Again, extremely hard to prove. So in many ways, we're limited in terms of what we can prove as far as incitement to genocide. In the realms of crimes against humanity, hate speech, not necessarily uttered with the intent to destroy a group, right, can be part of a widespread or systematic attack and therefore can be a crime against humanity. What is the crime against humanity in particular that applies to these types of hate speeches? It's called persecution. And I'm going to talk to you today about persecution as a crime against humanity with respect to speech. That's what I want to talk about. And in particular, I want to focus on a split between the International Criminal Tribunal for Rwanda and the International Criminal Tribunal for the former Yugoslavia. The two ad hoc tribunals that are currently running, ICTR is really close to shutting down, but each of them has taken a different position on this crime. The ICTY, in a case called Prosecutor versus Kordich, has said that hate speech, not explicitly calling for violence on its own, should not satisfy the conduct requirement for crimes against humanity persecution because it does not rise to the same level of gravity as the other enumerated crimes, such as murder, rape, some of the ones that I mentioned a moment ago. The ICTR says, yes, it should satisfy the actus reus requirement for persecution because the speech itself deprives the victim group members of fundamental rights. It excludes them from society, both socially and ultimately physically. So which position makes more sense from a policy perspective, a common sense perspective, even a legal perspective? That's what we're going to grapple with today. And what I'd like to do is start by giving you a little bit of a background into the origin of the crime of persecution, okay? First, we'll look at crimes against humanity. How did those come about? Then specifically persecution. Then persecution and speech, and we'll talk about the cases that deal with that. We'll then try to talk about the split between the ICTY and the ICTR. And there was an appeal in the media case, the case that I worked on when I was at the ICTR, where there were unresolved issues, and I want to talk about that. I want to talk as well about hate speech in terms of what it might mean as far as the crime is concerned, because people just talk about hate speech generally. And it occurs to me that it might be important, in fact, it might be necessary to parse hate speech into different categories so we can understand whether it satisfies the actus reus requirement. So I'd like to propose a parsing of the concept of hate speech and then talk about it as an actus reus. Finally, I'd like to talk about potential limits I'm not saying, you're going to hear me say, and I'll come right out and tell you, that I believe that hate speech ought to qualify as the actus reus for crimes against humanity persecution, but I think there may have to be limits in certain cases. I'm going to talk about limits related to the so-called chapeau, which I'll explain. It's kind of cool because I am literally going over the same stuff in my human rights class. Like yesterday, we were talking about crimes against humanity and the chapeau, so it's neat to be talking about it here with all of you. And then speech-related limitations. In other words, looking specifically at speech issues, not crime against humanity issues, and seeing limitations. And then I will conclude. Now, I want to talk about the origins of crimes against humanity, and then, as I said, I'm going to get into persecution itself, and then persecution in speech. The crime has its origins in the First World War with the Armenian Genocide. And in particular, on May 24th, 1915, it says May 28th, it should be May 24th. I know because that's my birthday. I think it's like a cool date in history that, you know, it's my birthday. Great Britain, Russia, and France, the allies in that conflict against Turkey, issued a statement to Turkey, a joint declaration, noting that, quote, in view of the crimes of Turkey against humanity and civilization, the Allies would hold personally responsible for these crimes all members of the Ottoman government and those of their agents who were implicated in such massacres. That, my colleagues and friends, is the beginning of crimes against humanity right there. It was included then in the Nuremberg Charter. Unfortunately, it wasn't prosecuted during World War I. Fast forward to World War II. Without crimes against humanity, given the limited reach of war crimes, right? War crimes had been around for a while. If you go back to 1864 and the Geneva Convention and the 1899 and 1907 Hague Conventions, the notion of war crimes was there, and it was discussed during World War I and even prosecuted to a very limited extent, but not crimes against humanity. If you had to count only on war crimes as a viable charge, you'd be in trouble because high-ranking Nazi officials before the International Military Tribunal, that was the big trial at Nuremberg, the first trial, you know, they had committed crimes against their own citizens, but war crimes didn't cover that. So there really wasn't much that you could do. So they had to include crimes against humanity, and it was included in Article 6C of the Nuremberg Charter. 6C tells us that murder, extermination, enslavement, deportation, and other inhumane acts committed against any civilian population before or during the war, or persecution on political, racial, or religious grounds in execution of or in connection with any crime within the jurisdiction of the tribunal, whether or not in violation of the law of the country where perpetrated. That's crimes against humanity. So the London Charter essentially contemplates two categories of crimes against humanity if you look at the text. First of all, certain inhumane acts, right, such as murder and the others, and then persecutions on discriminatory grounds, the grounds that are listed. Fast forward again to the 1990s, and let's look at Article 3 of the International Criminal Tribunal for Rwanda. That is the Crimes Against Humanity provision, and it states, the International Tribunal for Rwanda shall have the power to prosecute persons responsible for the following crimes when committed as part of a widespread or systematic attack against any civilian population on national, political, ethnic, racial, or religious grounds. This is the chapeau that I talked about earlier. Who knows what chapeau means in French? Hat, everybody, it's great. The French proficiency here is impressive. But a hat obviously goes at the top of a head, and it goes at the top of the statute. And this is what makes it an international crime, because otherwise, if you just look at the other ones, you know, murder, rape, you know, rape's not in there, it's going to come later, enslavement, deportation, these could be domestic crimes. But for our purposes, you know, this is, I just want to mention, this is roughly comparable to the International Criminal Tribunal for the former Yugoslavia, Article 5. It's basically the same statute. There's some changes, but we don't need to go into those today. Fast forward again to 1998, the Rome Statute of the International Criminal Court is promulgated. And it states in Article 7, for the purposes of this statute, crimes against humanity means any of the following acts when committed as part of a widespread or systematic attack. You see that widespread or systematic attack? That is now clearly part of the law related to crimes against humanity, as part of a widespread or systematic attack. And then I put this in brackets. Later on in the statute, it tells us that this means multiple commission of such acts by either a government or an organization, or I should say pursuant to a government or organizational policy, directed against any civilian population with knowledge of the attack. And then, of course, there's a list of enumerated acts, which are very similar to the other ones, expanded a little bit, but including murder, extermination, enslavement, deportation, imprisonment, torture, rape, and sexual slavery. It also then specifies in H, persecution. So persecution is now, again, one of the enumerated acts. Persecution against any identifiable group or collectivity on political, racial, national, ethnic, cultural, religious, gender, right? So the grounds are enlarged, or other grounds that are universally recognized as impermissible under international law. And then you'll see, I have in bold, in connection with any act referred to in this paragraph or any crime within the jurisdiction of the court. So if you're going to charge crimes against humanity persecution, you're going to have to tie it to one of those other enumerated crimes, murder, rape, enslavement, deportation, or one of the other core crimes, genocide or war crimes. Okay? So that's an important point. You'll see why later. I'm going to come back to that. But I also want to point out, moving down after H is persecution, I is the enforced disappearance of persons, J is the crime of apartheid, right? You all remember that from the horrible years in South Africa. And then K is other inhumane acts of a similar character, intentionally causing great suffering or serious injury to body or mental or physical health. Now, for the purposes of paragraph 1, we are told that attack directed against any civilian population means a course of conduct involving the multiple commission of acts, that's what I referred to above, the multiple commissions of acts referred to in paragraph 1 against any civilian population pursuant to or in furtherance of a state or organizational policy to commit such attack. Again, that's going to be key coming up. And then persecution means, and it's a little bit off the edge of the slide, so I apologize, it means the intentional and severe deprivation of fundamental rights contrary to international law by reason of the identity or group or of the collectivity. So, we now have a definition of persecution, so we're making progress in terms of fleshing out what this crime is. So, the other thing that tells us how this crime works is the case law. And we have cases from Nuremberg and the International Criminal Tribunal for the former Yugoslavia. Now, the Nuremberg cases provide us examples of persecution, but they don't really give us a concrete definition. And the ICTY cases do give us definitions and elements. So looking at them together, we'll have very good insights. Let's start with the Nuremberg cases. Now, in its general finding of Nazi persecution of the Jews, the International Military Tribunal, trying the major war criminals, this was the first trial at Nuremberg, focused on the passing of discriminatory laws, the exclusion of members of an ethnic or religious group from aspects of social, political, economic life, and the creation of ghettos. Now, what you'll notice about that list is it doesn't necessarily include direct physical violence against the victims. That's the point I want to make right now. And as part of the subsequent Nuremberg military trials, there were 12 trials that were conducted by a U.S. military tribunal after this main trial of the top guys, the Goerings and the von Ribbentrops and the Hesses. Afterward, they looked and they had trials that were based on themes. They had the justice trial, which was the Nazi judges and lawyers. They had the medical trial, which was the Nazi doctors, right? And they had 12 of these. And they also, some of those cases gave us some insights into persecution. So, for example, in the justice case that I just mentioned, which, by the way, is the subject of the movie Justice at Nuremberg from 1961, great flick, highly recommend it, see it if you can. But from that case, the Nuremberg Military Tribunal, not the International Military Tribunal, the Nuremberg Military Tribunal, found that the use of a legal system to implement a discriminatory policy constituted persecution. Again, the point of this is that it's pretty broad. It's not direct physical violence, it's more sort of bad social things that are being committed against the group. All right, then we come to the ICTY cases, right? We got good examples from Nuremberg, but finally with the ICTY cases, we get some concrete elements. And Tadich, which was the first case that was prosecuted before an international tribunal since Nuremberg, gives us a test. The trial chamber laid out 3 foundational requirements for persecution. First, the occurrence of a discriminatory act or omission. Second, a discriminatory basis for that act or omission on one of the listed grounds, specifically race, religion, or politics. And in other words, that goes to the mental state of the persecutor. Was the persecutor looking to discriminate on those grounds? And then third, the intent to cause and a resulting infringement of an individual's enjoyment of a basic fundamental right. Okay? That's the most information that we've gotten in terms of a legal test for persecution. And moving forward, we'll get more. We get that from the Kupreskic case. In Prosecutor versus Kupreskic, another ICTY trial chamber formulated a 4-part test for determining whether conduct can satisfy the actus reus requirement for crimes against humanity persecution. So, up till now, right, we've been looking at Tadich, sort of at general requirements. Now we're homing in on the actus reus. Because remember, the actus reus is the thing that's in dispute between the ICTY and the ICTR. So this is very important. And they tell us that the 4 prongs of this test consist of, first of all, a gross or blatant denial, okay, gross or blatant denial on discriminatory grounds of a fundamental right laid down in international customary or treaty law, and finally, reaching the same level of gravity as the other crimes against humanity enumerated in Article 5 of the ICTY statute. Remember, Article 5 is the Crimes Against Humanity statute. And you'll also remember at the beginning of this lecture, I mentioned that the nub of the dispute between the ICTR and the ICTY is whether persecution, or rather hate speech, rose to the level of the other crimes, right? And I'm telling you right now that this 4th prong is where the dispute arises, okay? This is the crux of the issue. Now, because that 4th prong is so important, I wanted to bring to you as well some observations that the Kupreskic court or chamber made about it, okay? In setting out the 4th prong of this test and in formulating it as a prong, the chamber cited to the NMT, remember the NMT is the subsequent Nuremberg trials, the Flick decision. Flick was one of the 3 industrialist cases, all right? There was Krupp, there was Flick, there was I.G. Farben, all right? Now, the Flick decision is then cited, and a passage in particular that focused on the distinction between crimes against property and crimes against the person. And in particular, Nazi expropriation of industrial property. This passage, which is the basis for prong 4 of the test, focuses on Nazi expropriation of industrial property from Jews. And the point being that that was not sufficient, it was not of sufficient gravity vis-a-vis various offenses against the person. For example, expropriation of personal property or destruction of personal property as opposed to industrial property. So from this passage, I submit to you that one can infer that within the crimes against humanity context, offenses directly against the person ought to be considered sufficiently grave pursuant to prong 4 of the Kupreskic actus reus test. Maybe not offenses against property, maybe personal property, but certainly not industrial property, okay? There's a couple of other points that the Kupreskic chamber makes that I think are worth focusing on. First of all, a narrow definition of persecution, the chamber tells us, is not supported in customary international law and was understood by the International Military Tribunal to, quote, include a wide spectrum of conduct ranging from discriminatory acts targeting general, political, social, and economic rights to attacks on the person. Remember, when we went over the Nuremberg cases, it seemed like there was a very wide range of conduct that applied. So that seems to be consistent. Second, that persecution is commonly used to describe a series of acts rather than a single act. And acts of persecution will usually form part of a pattern practice and must be regarded in their context. Okay? These are important points, because when we get to this dispute between the ICTY and the ICTR, we need to understand this. okay? And then finally, as a corollary to B, discriminatory acts charged as persecution must not be considered in isolation and may not, in and of themselves, be so serious as to constitute a crime against humanity. So, for example, curtailing the rights to participate in social life, such as visits to public parks, theaters, or libraries, must not be considered in isolation, but examined in their context and weighed for their cumulative effect. In other words, these individual acts typically are part of a larger campaign to inflict harm on the social group. So you can't look, for example, at a prohibition on going to a public park and say, well, that's not sufficiently grave. What they're telling you is you have to see it in the entire context, because within that context, it may very well be. All right, so now we understand crimes against humanity, now we understand persecution. What about speech and persecution, right? Because we're looking at this in layers. We've looked at the bigger crime, we've looked at the specific crime of persecution, and now we're going down to the final point, which is speech and persecution. Again, I want to focus at the judgments at Nuremberg. I want to look at the ICTR trial chamber judgments, because those are the ones that conflict with the ICTY. Then I want to look specifically at the judgment in Kordich, which is where all this controversy stems from. Then I want to look at a Canadian Supreme Court opinion, Mugesera versus Canada, and then finally that appeals judgment that I mentioned to you for the case that I worked on. Now, at the Nuremberg cases, we see mixed results. First of all, we have Julius Streicher, who was the editor-in-chief of an anti-Semitic Nazi rag called Der Stürmer. He was found guilty of crimes against humanity persecution based on 25 years, and I quote the court, 25 years of infecting the German mind with the virus of anti-Semitism and inciting the German people to active persecution and calling for murder when Jews in the East were being killed. All right? A lot of the murder operations of the Nazis occurred in Poland and Russia, and Streicher was saying horrible things in his newspaper during that time while aware that that was going on. Hans Fritzsche was found not guilty. He was the head of the radio section in Joseph Goebbels' propaganda ministry. He was found not guilty because his speeches, the tribunal said, did not directly urge persecution of Jews, and his position and official duties were not sufficiently important. I think that this is a horrible decision. I plan to write an article criticizing it, if not a book, and so to be continued, all right? The third one is Otto Dietrich, and he was found guilty for speech aiming to enrage the Germans, justify persecutory measures, and subdue doubts about persecution. You'll notice that there's nothing in there about direct physical violence, and that's a key point. I'm going to be giving a talk on this Dietrich case at Harvard Law School in April, and I'm going to basically take this part of my talk here, and I'm going to expand it. I'm going to look at the Dietrich case in great depth. So, also to be continued. The ICTR trial chamber judgments, the two that we really need to focus on are Georges Rougiou, 2000 case where the tribunal found that discriminatory verbal attacks on Tutsis gave rise to liability for crimes against humanity persecution because it deprived the Tutsis of fundamental rights to life, liberty, and basic humanity that were enjoyed by members of the wider society. The media case from 2003 held that crimes against humanity via speech, or I should say crimes against humanity persecution via speech can be committed without the speaker explicitly calling for violence. The words themselves attacked the victims. They were not merely a medium through which to encourage others to perpetrate acts of violence independent from the words. That's the crux of incitement to genocide. This is different. Here, the words themselves constitute the violation. There are a couple of other points that we can glean from the ICTR decisions. First of all, in accordance with the four-prong actus reus test of Kupreskic, hate speech rises to the same level of gravity as the other enumerated crimes against humanity in all circumstances. So that's a pretty bold statement by the ICTR. And this is, the reason this is because hate speech is not protected speech under international and domestic law. We can look at the International Covenant on Civil and Political Rights, for example, which tells us that hate speech is not protected speech in certain circumstances. The Convention on the Elimination of Racial Discrimination, or CERD, does the same thing. And there are a lot of codes in various domestic jurisdictions that outlaw certain kinds of hate speech. The United States, just to give you some perspective, is the most speech protective country in the world. We are off the charts, far more protective than any other country in the world. So it's not necessarily indicative of the way things go internationally to look at US law. And then another point, based on the chapeau's mens rea, right, we looked at the chapeau, that's the thing at the top, and the mens rea of crimes against humanity, by the way, is knowledge that the acts that are being committed are part of the widespread or systematic attack. That too is extremely important. Based on that, the perpetrator must speak those words, knowing that it's part of a widespread or systematic attack against the civilian population. And at the International Criminal Court, I would point out parenthetically, that is part of a state or organizational plan or policy. So the speech is not an isolated instance of hate mongering, not connected to physical violence or inhumane treatment. It is absolutely connected. It has to be because of the mental element. It must be linked to the widespread or systematic attack. All right, finally, we get to the pièce de résistance, Kordic, from 2001. Okay, we've been sort of leading up to this. Kordic was a Bosnian Croat politician who was charged with crimes against humanity persecution based on, and I quote, encouraging, instigating, and promoting hatred, distrust, and strife on political, racial, ethnic, or religious grounds by propaganda, speeches, and otherwise as part of an ethnic cleansing campaign against Bosnian Muslims. All right? And curiously, the indictment and the judgment itself never specify which speeches are the subject of the persecution count, or it never conducts any legal analysis with respect to the text of any such speeches. It essentially ignores the speeches altogether, which is pretty amazing. The judgment provides, on the other hand, the description of the defense counsel of alleged speeches as non-inflammatory and non-discriminatory. And the prosecution's arguments against this are not reflected in the judgment. It seems as though the nature of the speeches is not even at issue. It almost seems, if you read the judgment, as though everybody agrees these weren't hate speeches. They don't even come close. So, as far as the judgment itself, the chamber begins by acknowledging, first of all, that the actus reus for persecution requires no link to crimes enumerated elsewhere in the statute, unlike the ICC statute, right? Acts of persecution must be evaluated not in isolation, but in context by looking at their cumulative effect, right? That's what we saw from the other decisions, and it acknowledges that. Third, the crime of persecution encompasses both bodily and mental harm and infringements upon individual freedom, okay? It acknowledges all those things. And then it specifically applies the Kupreskic actus reus test, but it finds that the speech at issue could not amount to persecution because encouraging and promoting hatred on political, racial, ethnic, or religious grounds cannot by itself constitute persecution, okay? It says it does not rise to the same level of gravity as the other crimes enumerated in Article 5, and the prohibition against this kind of activity has not attained the status of customary international law, right? That was the third prong of Kupreskic. So it says it doesn't meet prong 3 because it doesn't rise to the level of international customary law, and secondly, it is not of the same gravity as the other enumerated acts. Let me point out a couple of other things that are mentioned by Kupreskic. It talks about Stryker, right? And it says the IMT convicted Stryker because he incited to murder and extermination, not based on speeches not directly calling for violence. So it takes one part of Stryker and it says this is what Stryker is all about. It doesn't look at that language that says that Stryker's speeches were like a virus that infected the German mind against Jews. Doesn't look at that, all right? It also looks at a conviction from the ICTR from 1998 against Jean-Paul Akayesu, who was a mayor. It was the first ICTR conviction. Basically, he was the first guy that got into custody. And there was a point in the case where the prosecution pointed out that he spoke to some militia members, and because of that, he was convicted of incitement to genocide. This is not a big media case. This is not a case where speech was a focus of the case. It was an incidental thing. It points that out and it says, hey, you know what? At the ICTR, if there are any speech cases, they're strictly incitement to genocide. Now, I don't know if you noticed the years, but this is 2001, right? Remember I told you Rougiou was 2000? So I'm wondering about that statement. If you're saying that the ICTR and speech is limited to incitement to genocide, what about Rougiou? And then it says the only speech act explicitly criminalized under the statutes of the International Military Tribunal, Control Council Law Number 10, which was the Nuremberg Military Tribunal Law, and the ICTY, ICTR, and ICC statutes is direct and public incitement to commit genocide. Of course, this completely ignores the fact that crimes against humanity persecution has been used to prosecute hate speech since Nuremberg. But that's okay. And then it says there is no consensus regarding criminalization of hate speech, and it really only cites the United States and says, hey, the United States does not criminalize it, so therefore it does not represent customary international law. Now, I mentioned Mugesera. Mugesera is a 2005 immigration case. I don't want to spend a lot of time on it, but it involved an infamous speech before the Rwandan genocide, and Mugesera was accused of making the speech and then fleeing Rwanda and going to Canada, and Canada was trying to deport him based on the speech. The point is that the Canadian Supreme Court looked at both the Courtich and the ICTR approaches, and it implicitly rejected Courtich. Okay? So this is 2005. Then we get the media case appeal, because up till now I'm just talking about the trial chamber judgment, okay? The appeals chamber affirmed that hate speech targeting a population on the basis of ethnicity or any other discriminatory ground violates the right to respect for the dignity of the members of the targeted group as human beings, and therefore constitutes actual discrimination. This is a key point of the ICTR's decision in the media case, and it's saying, yes, we agree. It also held that speech inciting to violence against a population on the basis of ethnicity or any other discriminatory ground violates the right to security of the members of the targeted group and therefore constitutes actual discrimination. Okay, that also gives us some important insights. However, the appeals chamber refused to resolve the dispute